Hi, everyone. My name is Patricia Dean. Everybody calls me Pia, and you should feel free to as well. Welcome to the webinar on responding to noncompliance. We're going to be covering the topics of self-reporting and repaying today. I want to be very respectful of your time, and this is a hard topic to get through in an hour. So I may not be able to respond to any questions you have until after the webinar, but feel free to put in any questions. This is being recorded, so I can go back and respond to your questions. Likewise, you can always email me. Feel free to do so. I recognize several of your names and have talked to some of you. Others I've not had the pleasure of meeting, but always feel free to contact me if you'd like. My contact information is at the end of the slides, and I'm glad to talk to any of you anytime. Starting in, I want to talk about what we're going to cover today. The first is the compliance issues that may result in a repayment obligation. So what is it? What kind of activities will require you to report and repay? And we're going to look at the Affordable Care repayment requirements. As most of you know, we've had repayment obligations since 1995, but the ACA, which became effective in 2010, really upped the ante on report and repayment requirements. And then we're going to talk about self-disclosure processes under the proposed report and repay rule, the OIG Self-Disclosure Protocol, also often referred to as SDP, and the CMS Self-Referral Disclosure Protocol that applies to Stark violations, also referred to as the SRDP. And then lastly, we're going to look at practical suggestions for avoiding or responding to potential repayment issues. Hopefully you've all received the written materials. They should be in your chat box. They include a copy of the slides, the CMS proposed repayment rule, and I'll just point out right now that while it's still a proposed rule, it is the law. It is in effect, and CMS treats it as such. So while there's not a final rule yet, the proposed rule is being applied to all of us. And so you have a copy of that. There's also the OIG Self-Disclosure Protocol, open letters modifying the Self-Disclosure Protocol in 2006, 2008, and 2009. Then the CMS Stark Self-Referral Disclosure Protocol. And lastly, OIG's roadmap for new physicians avoiding Medicare and Medicaid fraud and abuse. It's just a good PowerPoint presentation that can be very helpful providing an update of information. As I just said, this presentation will be recorded and will be available at the HH Health Law blog. If you have questions, you can contact me. There's my contact information. And if you experience any technical problems, if you for some reason get thrown out of the call or experience anything else, you can contact Luke Kelly. He's wonderful, and he'll be glad to help you any way he can. His email address is there as well. One other preliminary matter, since we're lawyers, we feel the need to remind you all of this. These are simply educational materials. We are not pretending that we can answer any specific questions. This area of law in particular is fact-intensive. So remember that if you have an actual situation, you probably want to talk to legal counsel about that. This presentation does not create a client-attorney privilege or relationship, and so please understand that this is just simply for educational purposes. So let's start in. What causes non-compliance issues? Basically, the idea is that if you want government money, you have to comply with the government's conditions. They go hand in hand. And failure to comply with conditions may result in obligations to make repayment, penalties, and also reporting requirements. Failure to comply with conditions of payment include billing practices such as services that are not medically necessary, services that are not covered by a federal program, services not provided as claimed, services not provided by a licensed provider, substandard care, duplicate payments or double billing, upcoding, and the like. And there are endless examples of things that can lead to reporting and repayment obligations, but those are common ones. So there are several statutes that typically lead to report and repay requirements, and we're going to talk about them. They include the Anti-Kickback Statute, the Stark Law, civil monetary penalties, and the like. If you need a refresher on any of those particular statutes, my partner Kim Stenger just did a webinar, I think earlier this month, about Stark and Anti-Kickback. That's available on our website. We also have written materials available. So if you feel like you need a refresher on any of these statutes, the materials are available. I'm going to not go over the specifics of these statutes because of time limitations, but instead talk about what is required in terms of report and repay. So starting with the Anti-Kickback Statute. The Anti-Kickback Statute says you cannot knowingly or willfully offer, pay, solicit, or receive remuneration to induce referrals for items or services covered by a federal health care program unless the structured transaction fits into a regulatory exception or safe harbor. The AKS is very broad. It potentially applies to any transaction between referral sources or program beneficiaries. So it is not specific just to physicians. And I want to point out that remuneration is equally broad. It is not just payment of cash. It can be anything from sports tickets to golfing rounds, anything that has potential value and is provided by one person to another to encourage or induce referrals is a violation of the Anti-Kickback Statute unless you fit within a safe harbor. And there are numerous safe harbors. It's always good to be up on what those are. I want to remind you that it's a criminal statute, which means that it has an intent base. So you have to intend to be inducing referrals. There are, you have to intend to induce, and because it's a criminal statute, it includes criminal penalties, things like prison time and the like. So it's important to be in compliance with the AKS. Also, intent has been interpreted very broadly. So while we say it's an intent-based statute, it applies if even one purpose of the transaction is to induce referral. It doesn't have to be the only purpose. It doesn't even have to be the primary purpose. But so long as one purpose of the transaction is to induce referrals, it meets the Anti-Kickback Statute requirements. The penalties for the Anti-Kickback Statute include the following. It is considered a felony, which can result in a $25,000 fine and 5 years in prison. We'll talk about a case where currently a physician and a hospital administrator are in prison. There's $50,000 administrative penalty, and really importantly, it can lead to a permanent or temporary exclusion from Medicare and Medicaid. So it can literally take you out of all federally funded programs or federally reimbursed programs. Also important to know is that a violation of the AKS may also be a violation of the False Claims Act, and that has its own separate penalties on top of the Anti-Kickback Statute, which include penalties up of $5,500 to $11,000 per claim submitted. So you can imagine how quickly that adds up. They can also impose treble damages or 2 times damages if disclosure is made in a timely fashion. That's considered 30 days. And then also it can lead to qui tam or whistleblower lawsuits. So someone who becomes aware of the improper billing practice can bring a suit that the United States government can either decide to join in or not join in, but it can lead to additional damages above and beyond the criminal statute and penalty, monetary penalties involved. So obviously a very important statute. Here is the facts of the case I was just talking about. A hospital paid a referring physician $75,000 a year to serve as medical director, but failed to document that the physician performed services. And the anti-kickback exception for referrals requires a written agreement. They didn't have it. That had to be at fair market value. And so the physician and hospital administrator were both sentenced to prison and received $250,000 fines. They also had to repay all the amounts that the hospital received from federal programs based on referrals from the physician during the period that they were in violation of the Anti-Kickback Statute. And I've got to tell you, that amount exceeded the fines to both the hospital administrator and physician, just the loss of reimbursement. So significant. Next, I want to talk about what's known as the Stark Law. It's actually called the Ethics in Patient Referral Act, but it's commonly referred to as Stark because Pete Stark was a senator who originally proposed the law that has now been with us for generations, long since Senator Stark left the legislature. It applies to physician or physician family members' specific referrals. So unlike the AKS, which is broad and refers to anyone, including beneficiaries, any remuneration to anyone, this is physician referrals that we're talking about. If a physician or physician's family member has a financial relationship with an entity, the physician cannot refer patients to the entity for designated health services payable by Medicare, and the entity cannot bill Medicare for designated health services improperly referred unless the transaction fits within a regulatory exception. There are many exceptions that provide for referrals. It's good to know what those are so that you are aware that some referrals are completely permissible, but again, as a general rule, not permissible unless you can fit within an exception. This is a civil statute, and that means that no intent is required. Intent is irrelevant. It can be an honest mistake made with no intent to induce referrals, but it can still be a violation of the Stark Law. And there is no good faith compliance. The fact that you were trying to do the right thing, the fact that the physician in the prior example, that they had intended to get a written agreement in place but did not, that doesn't make any difference. You're still in violation of the Stark Law. Designated health services, what are those? That is a specific term of art to the statute. It includes inpatient and outpatient hospital services, prescription drugs, clinical laboratory services, occupational, physical, and speech therapy, radiology services, durable medical equipment. That's a fairly good list there. But you should also know that CMS maintains a list of CPT codes, which is updated annually, that covers everything that falls within a designated health service. And in fact, if you end up in a situation where you're trying to assess whether there's been a compliance breach for your particular office or entity, it's always good to make sure that the service that you're talking about that was referred falls within a DHS, and good to know that you can go to CMS and see an updated list. The penalties for Stark is that there will be no payment for the designated health services during the period of disallowance. So everything during that time period is not reimbursed from the government. You have to repay amounts received per improper referrals. So even those things that have been reimbursed by Medicare or Medicaid have to be repaid. And then on top of that, there's a $15,000 per claim submitted per penalty, and $100,000 per improper scheme. And then very much like the Anti-Kickback Statute, a Stark violation may also be a violation of the False Claims Act, resulting in penalties of $5,500 to $11,000 per claim, treble damages or 2 times damages if disclosed within 30 days. Also whistleblower lawsuits and exclusion from Medicare and Medicaid. Very significant penalties. I've given you an example of a Stark example, or a fact scenario, an actual Stark scenario. I won't go through that, but I wanted to give you an idea of an actual case that had been a violation of Stark. The next statute that I want to talk about is the Civil Monetary Penalties Law. This prohibits various actions, including submitting claims if services were provided by an excluded provider, employee, or contractor, and inducements to federal program beneficiaries to receive reimbursable services, such as discounts or waivers for copayments. It also includes inducements to limit services by hospitals, which we often call gain sharing, or failing to repay amounts when due. Under the Civil Monetary Penalty Law, the penalties include $10,000 to $50,000 depending on the conduct involved. So here they look at how egregious the behavior is, and they can change the level of penalty depending on that. But it also allows for treble damages and exclusion from the federal program. Violations of the Civil Monetary Penalties Law may also be a violation of the False Claims Act, resulting in $5,500 to $11,000 per false claim submitted. Again, treble damages, 2 times damages if timely disclosed, TTAM suits, and exclusion from federal programs. You can see there's a recurring theme there with AKS, Stark, and the Civil Monetary Penalties Law. They may also result in False Claims Act, which just causes the damages to increase dramatically. I've given you a civil monetary law case just to give you an idea of how it works, and I won't bother you. We won't go over that right now. So there are several different routes that you can take to repay. So if you have identified a violation, a billing issue, or a non-compliance issue, there are different routes you can take to repayment. The first is under the ACA, Section 6402, and that's a disclosure by the ACA. It may be less invasive than other approaches, the self-referral disclosure or the self-disclosure protocol, but it cannot resolve civil or administrative liability for conduct that led to overpayment, and accordingly is not as final. So you may not be solving all of your problems with disclosure under the ACA. And it will require repayment, but may not involve a penalty. So that's one of the nicest things about the ACA approach, is that while you're going to have to repay for sure, you may not have a penalty involved. Now, with the Self-Referral Discovery Protocol, the SRDP, under the Stark Law, it can resolve liability for overpayment and underlying Stark Law violations. It provides more certainty and provider involvement in resolution, but it will involve a penalty. So you have to just sort of accept that if you're going to go the self-reporting and repayment under the SRDP, that there's going to be a penalty involved. And the same thing is true of the OIG Self-Disclosure Protocol, the SDP. It can result in release from the civil monetary penalty law claims, and it can resolve permissive exclusion authority. It provides more certainty and provider involvement, so the provider, how they respond and conduct themselves during the investigation will all have an effect, but it will also involve a penalty. So let's talk about the ACA Repayment Law. This obviously came about in 2010 with the passage of the Affordable Care Act. It allows that if a provider has received an overpayment, the provider must return the overpayment to a federal agency, state intermediary, or carrier, and notify the entity of the reason for the overpayment. So under this law, whichever agency you decide to report to, you have to provide you not only have to return the overpayment, but also have to explain that the reason that the overpayment occurred. And you must report and repay within the later of 60 days after the overpayment is identified, or the date corresponding the cost report is due. So what is an overpayment? An overpayment under the ACA is defined as funds a person receives or retains to which the person, after applicable reconciliation, is not entitled. So it can be things such as payments for non-covered services, payments in excess of the allowable amount, upcoding, errors and non-reimbursement expenses in cost reports, duplicate payments, receipt of Medicare payments when another payer is primary, or payments received in violation of Stark, Anti-Kickback, or the exclusion statute. In other words, anything that is a misbill can potentially apply. Things that it is not. So the repayment law is a condition of payment for government programs, right? Billing claims, Anti-Kickback Statute, Stark Law, Civil Monetary Law. But it is not things such as conditions of participation, conditions of coverage, licensure, EMTALA, OSHA, or HIPAA. So none of those violations on the right-hand side of the screen involve repayment obligations, whereas on the left side, they do. Under the ACA, knowing failure to report or repay by deadline also implicates the False Claims Act. So again, if you have an obligation to repay and you don't repay, you're subject to a penalty, a monetary penalty that can be trebled, and QTAM potential liability, and also civil monetary penalty law violations. We've already covered those. Knowing means having actual knowledge of the overpayment or acting in deliberate ignorance of overpayment, or acts in reckless disregard of the overpayment. And we're going to talk about a case that's been very important that just came out in August of 2015. But this idea that you have some knowledge is enough to trigger your responsibility under the ACA Repayment Law. The original context, please remember that it does not require specific intent to defraud. So again, there is no intent in this statute. It can be done completely innocently. You may not have meant to do anything wrong, had been trying to do everything right. In fact, that's the majority of providers I deal with who find themselves in this situation have been trying to do everything right. Something has gone wrong. It happens all the time. We're humans. We know that it's going to happen. It doesn't require intent to defraud, but if you have to make an overpayment, or if you've received an overpayment, you must do something to respond. The original context giving rise to overpayment may not violate the False Claims Act or the Civil Monetary Penalties Law, but failing to timely repay overpayment may violate the FCA or the CMP. So I just want to remind you that while what happened originally may not implicate FCA or CMP, failing to respond and timely repay may implicate those other laws and get you into much deeper water in terms of penalties. So the proposed repayment rule, I mentioned this early on. The proposed repayment rule was issued in 2012, early 2012. Comments had to be due by April 16th of 2012, and still no final rule is out. That does not mean it's not in effect. It is, in fact, in effect and is being used on an hourly basis by CMS and other agencies. Under the proposed repayment rule, the provider's initial decision of where to refer a matter involving noncompliance with program requirements should be made carefully. Now, I've given you the Federal Register or the Federal Regulatory site for that, because that is the exact language that the Department of Health and Human Services uses, because they understand that deciding which route to go when you realize you have an overpayment issue or a noncompliance issue is very important. Multiple factors need to be considered in determining which disclosure protocol is best for the situation involved. And every situation is a little bit different. So this is why I say this is a very fact-intensive part of the law. So you're going to want to really consider which protocol is best for your particular situation. In addition to the benefits and limitations involved with each disclosure protocol, some hard rules do apply. So for stark law-only violations, that has to be disclosed through the Self-Referral Disclosure Protocol, the SRDP. But if you have a violation that is both an AKS and stark law, then you must use the SDP. The SDP should not be used for matters involving potential violations of federal, criminal, civil, or administrative law for which civil monetary penalties are authorized, matters exclusively involving overpayments or errors. So I want you to think of the SDP as where you go when you have fraud or an act that was knowingly made, intentionally made, and the like. To report and repay overpayments, you need to use existing voluntary refund processes. Self-reported overpayment refund process, you can find that in the Medicare Financial Management Manual. Use the form that the contractors or your fiscal intermediary maintain on their website. So if you're under Noridian, Noridian's website will include all the forms that you need to make repayments for common errors, overbilling, just mistakes, basically. Under the proposed payment rule, the report must include the provider's name, NPI, and tax ID number. That's probably standard. However, you must also include how the error was discovered, the claim number, the corrective action plan that you have implemented to avoid a repeat misbilling, whether the provider is currently under a CIA or under the OIG SDP, and the reason for the overpayment. So incorrect service date, insufficient documentation, wrong CPT code, lack of medical necessity, any of those kinds of things can be listed as a reason for overpayment. Then you also have to give the total amount of the overpayment And if a statistical sample is used, you need to include the method of calculation. And what's most important under the proposed repayment rule is that at the time you report, you must include the refund amount. So you report the overpayment and pay at the same time. That isn't true for other protocols, so we'll get to that here in a few minutes. You must return the payment within the later of 60 days, or if the overpayment is related to an issue in a cost report, the date the corresponding cost report is due, whichever is later. The overpayment is identified if a person has actual knowledge of the existence of an overpayment or provider acts in reckless disregard or deliberate ignorance. It is not necessary to know the amount of the repayment, and that's where I want to talk to you about this, the Kane case. This is Kane versus First Health. If any of you are particularly interested, I did a client alert on this in August. It's on our website. The law is out there, or the court's reasoning is out there. But what happened in that case is that a hospital, or an insurance group had a computer glitch, and that computer glitch was causing some billing errors automatically. And they were given notice of those billing errors by the New York State Comptroller's Office in September of 2010. The comptroller went to one of the hospitals, which was called Continuum, and asked that they figure out what was going on, that they thought there was a computer glitch. Continuum asked their employee, Mr. Kane, if he would look into the matter. 5 months later, he provided information to several managers at Continuum indicating that he'd found 900 missed payments, misbilling, that resulted in over $1 million of overpayments from Medicare or Medicaid. It is undisputed, it was absolutely known that Mr. Kane's calculations were not entirely correct. At least half of those claims that he thought were improper were not. Despite that fact, the court said that simply being aware that there might be a problem was enough to trigger the self-report and repay rule. To make matters worse, Continuum, 4 days after they received Mr. Kane's report, terminated Mr. Kane. So they fired him. And he, of course, became the whistleblower. He took the case to trial. The United States joined in, and it resulted in a significant fine. But most importantly, it gave us the law that simply says identified does not mean classified with certainty. Rather, if you're put on notice of a potential overpayment, you have a duty to report and repay. And the way the law puts it is, if you have notice of a potential overpayment, you must make a reasonable inquiry with all deliberate speed to determine whether an overpayment exists. Examples of identified overpayment: upon reviewing records, discover erroneous codes were used, discovered services were rendered by an unlicensed or excluded provider. This happens quite commonly, where you realize that a provider who may be excluded for one reason or another, some of his or her bills have gone into Medicaid and Medicare, or an internal audit reveals an overpayment, or there's a compliance hotline tip that notifies a provider of potential problems. So while we don't have an exact definition of identified in the proposed final rule, apparently overpayment is identified when existence of an overpayment is confirmed, or you've been put on notice, or you failed to make reasonable inquiry. By the way, in the Kane decision, the court put out a very well-reasoned 30-plus page opinion in which it went into great depth about Continuum's failure to take action despite the comptroller's notice, and then the fact that when Mr. Kane came to them and gave them some proof of it, they still did nothing. They didn't make payments until 2013, and that was considered completely unacceptable. We are hopeful that the final rule will clarify when an overpayment is identified, but for now, we believe that if you knew or should have known that an overpayment occurred, that is enough to trigger the rule. There is no minimum threshold for the repayment rule, so it can be as simple as one single missed claim. And it is not clear how the proposed repayment rule works with existing processes. For instance, when you submit an adjusted request or a rebill or you address in a credit balance, it's unclear right now how the proposed repayment rule deals with that. my strong recommendation is to work with your contractor on those issues and work with them on repayment. It's also not clear how far back a provider must look when evaluating repayment. CMS may reopen claims within 1 year for any reason, within 4 years for good cause, or any time due to fraud or fault. So there is no statute of limitations where fraud or fault are involved. The False Claims Act statute of limitations is 6 to 10 years. Most of us think of it as 10 years just so that we're on the outside of that. And the proposed repayment rule would extend look-back and reopening period to 10 years, although there is some indication, and there's been lots of comments to the department suggesting that it should be a shorter period of time or that it should depend on the type of repayment issue involved. Again, no final rule on that yet. If you need more time to repay, there is a process for doing that. It's the Extended Repayment Schedule, ERS. It is not automatically granted. You will be required to submit significant documentation to demonstrate financial hardship. And you must still report the overpayment within 60 days. So my suggestion, and I've used this process, is simply to report and then request the ERS process, providing lots of information to the contractor at the time that the disclosure is made. Under the proposed repayment rule, repayment does not involve violations or penalties under other laws. So this is not the method you're going to use when you have an anti-kickback statute violation. Same thing for CMP, False Claims Acts, which are resolved by the Office of Inspector General or the Department of Justice, and STARK, which is resolved by CMS. If a Medicare contractor believes repayment involves violation of federal law, the contractor may report repayment to OIG, CMS, or other federal agencies. So be aware. Simply going to your contractor does not immunize you from the potential that OIG, CMS, or even DOJ will become involved down the road. And you may want to consider other disclosure protocols, such as the SVP or the SRDP, when you're thinking about what is the best route to report and repay. Participation in the OIG Self-Disclosure Protocol or the STARK Self-Referral Disclosure Protocol suspends the time for refund under the repayment law. So if you find yourself in the position of needing to report and repay, if you are using the SVP or the SRDP, your time for responding to the repayment law is suspended. And for SVP, timely disclosure to OIG constitutes a report for purposes of repayment rule. And for the SRDP, you may still make report within 60 days to a government agency, state, or fiscal intermediary or contractor. The open issues from the proposed rule, and we've already touched on them, but they still include the definition of identification, the length of the look-back period, and the interplay with other processes. Just want you to be aware that those are still open issues that have not been confirmed yet. But as I said, the rule is in effect. That's my next point. Proposed rule is now the industry standard. CMS has made it clear that the 60-day rule is self-implementing and the reality even without a published final rule. And then I've already covered the facts of Kane versus Health First, but that just gives you a quick review of that case. Very, very instructive and very much a cautionary tale. So let's go to the OIG Self-Disclosure Protocol. It's a voluntary program. You don't have to use it. The benefits is that the OIG may reduce penalties if you fully disclose and cooperate. There's probably no corporate integrity agreement, no CIA, that you're going to have to deal with. It may preclude QUETAM sites or lawsuits. So the fact that you've reported and been involved is most likely going to persuade the United States government that they do not want to join into a QUETAM lawsuit, and that often precludes those kinds of suits from happening at all. And it suspends repayment under the proposed repayment rule. But there's always risks. Point of the slide. The risks are that there's no guarantee that the OIG will reduce penalties. So you can hope that they will, but there's no guarantee that they will. The penalties are huge. They can be significant, and they can literally destroy a practice. The OIG may broaden its investigation, so you may go and disclose on one thing. Once they start their internal process, they may broaden their investigation to other things. New matters discovered by OIG are outside the protocol. Failure to fully disclose or cooperate may result in additional penalties, so they can come down hard if they feel like you withheld information and the like. And the OIG may report to other government agencies. The participation is often burdensome. You're likely to waive privilege, and the information is likely to become public. As I mentioned earlier, the SDP should only be used to resolve matters that potentially violate federal, criminal, or civil or administrative law. Matters exclusively involving overpayments or errors that do not suggest that violations of law have occurred should be brought directly to the attention of your contractor. So, generally, the SDP applies to violations that involve actual knowledge of a problem at the time that the billing was made, reckless disregard, or deliberate ignorance. So, if you are not paying attention and putting out bills that other people would suspect or you should have known could be a problem, then you're likely to be under the SDP. But don't use it for honest mistakes or simple billing errors. And it also should not be used for things that are solely stark referral law violations. The OIG Self-Disclosure Protocol is put out on a website. The site is included. This is what the page looks like. It has a lot of information on it. It provides lots of guidance. All of the forms are there. So I recommend that you take a look at this before you ever need to, just to get an idea of everything that's covered. It's pretty inclusive. The SDP process, if you discover ongoing fraud, so if you find something that is actually fraudulent, in other words, intended to be misbilling with criminal intent, you should contact the OIG immediately. Stop right there. If you find fraud by one of your providers or the like, stop and report. Otherwise, if you're not sure and something looks amiss, you need to conduct an initial investigation to confirm that the SDP applies. And once you have, then you need to submit a disclosure to IG including the following information. Information about the provider, address, NPI, tax ID, organizational chart. Then you also need to give a complete description of the conduct disclosed. Describe the internal investigation that you've conducted or the estimate of when it will be completed. An estimate of damages to federal programs, including the method for calculation or estimate of completion. Whether you're under investigation, laws potentially violated. And by that I mean be very specific. You can't just say generally federal laws, rules, and regulations. You need to identify the law that you believe has been violated. You must acknowledge the conduct is partly a violation, you must have it must be certified by an individual authorized to enter into settlement. So, in other words, it must be signed by an authorized person. Disclosures must be submitted through the OIG's website, so you can do it electronically. They will also take hard copy of submissions, but no faxes. And as I pointed out, the SDP provides guidance on what to include for specific conduct. So when you go onto the website, you'll see that there is a specific protocol for excluded persons or for false billing. Very, very helpful from that standpoint. The SDP process includes the internal investigation, so you want to take a look at the nature and extent of improper action, discovery and response to the matter. So this is once you've disclosed, this is the information you want to provide. Next, the OIG will verify the information in a report. So you receive a report back from OIG, and the OIG will require an access to all audit and other papers without regard to privilege. So you're basically giving up privilege for any documents that you have. And you must respond timely to OIG requests for additional information. And payment, you do not make payments while the SDP is pending without OIG approval. So if you're under the Self-Disclosure Protocol, unlike the proposed prepayment rule, you don't submit repayment, you hold on to it. But you are encouraged to place that money in an interest-bearing escrow account. The government very strongly encourages that, and it is typically a sign of good faith. As I mentioned earlier, the way in which you conduct yourself during a self-disclosure protocol is very important. This is from the Federal Registry. They say directly, if a provider fails to work in good faith with the OIG to resolve the disclosed matter, the lack of cooperation will be considered an aggregating factor. So they can actually up your penalty based on the fact that you were not helpful or in any other way were obstructed the process. So the tail there is, if you end up in an OIG self-disclosure protocol, be sure to cooperate fully. The OIG has periodically modified the SDP. There was an open letter in 2008, another in 2009, and the most recent was in 2013. That settled several issues. These are available, by the way, in your written materials. The most important of the updates in the 2013 open letter was a minimum of $10,000 penalty for all non-anti-kickback statute matters disclosed. So when I said that there will almost surely be a penalty, that comes from the 2013 open letter. And lastly, when you're dealing with the SDP, do not assume that you can avoid all penalties. Like I just said, you're not going to, most likely. The OIG seems to have established formulas or protocols for handling certain kinds of claims. Like I mentioned, excluded providers or improper billing. They have a protocol for looking at each one of those. And remember that under the False Claims Act, disclosure within 30 days reduces penalties to 2 times actual damages. So again, under the under the False Claims Act, they can treble your damages. But if you report within 30 days, once you know that there's a problem, that reduces penalties to 2 times damages. It can make a very big difference. Just a reminder of how big these awards can be in the SBP. In 2014, there was a total of $23 million recovered under the protocol, and I've given you a couple of examples: a hospital operation of a ambulatory surgical care unit and potential anti-kickback statute violations. They had a $1.7 million settlement. Another home health care provider billed hospice services without required certification documents, and that was a $2 million settlement. So the amounts can be overwhelming and very, very difficult to absorb. Next, I'd like to go to the Stark self-referral disclosure. So again, now we're dealing with physician referrals that are improper and don't meet an exception, and what you have to do to disclose a referral under a matter such as this. Again, this is a voluntary program, just like the SDP. The benefits, CMS may reduce penalties if you fully disclose and cooperate. Again, how you conduct yourself during an investigation makes a very big deal. It may preclude KETOM lawsuits. It suspends repayments under the proposed repayment rule. So again, you don't have to submit repayment at the time of disclosure. And it allows for some finality. It may maintain more confidentiality versus the OIG SDP. So let me go back. The OIG's self-disclosure protocol, that information becomes very public. It's posted names and settlement amounts on the website. The CMS has been much more closed with the self-referral disclosure protocol, and they may include information about a settlement, but they typically do not include names. And you'll see that I've put not in green on these slides, and that's because in the slides that went out to you this morning, I had a typo, and I apologize. I left out the not, so I just wanted to point that out to you. So names are not included on the website. If an issue relates to both the SRDP and the SDP, it should be reported under the OIG SDP. I mentioned that earlier. If you have a Stark-only violation, SRDP, but if it's a Stark violation with something else like anti-kickback, you want to report under the OIG's self-disclosure protocol. There are risks, very similar to the risks with the SDP, the OIG self-disclosure protocol. Under the Stark self-referral disclosure protocol, there's no guarantee that CMS will reduce penalties. CMS may broaden its investigation. Failure to disclose or cooperate may result in additional penalties. CMS can report to other governmental agencies, and participation is fairly burdensome, but not as burdensome as the OIG Self-Disclosure Protocol. You're likely to waive appellate rights concerning any overpayment. You're likely to waive all privilege, and information may become public, but typically not in as onerous a way. Again, I'm just mentioning again, use the SRDP for confirmed start violations. Assume that you're going to pay. And you can use alternative processes to obtain CMS guidance. I really strongly urge you to take a look at advisory opinions that are available. I've given you the site, and also CMS Start Frequently Asked Questions. One of the most important things you need to do is figure out whether you actually have a violation under START before you enter into the Self-Referral Disclosure Protocol. Under the Self-Referral Disclosure Protocol, you must disclose within 60 days. And you must repay within 60 days after receipt of payment pursuant to improper referral or subject to a $15,000 penalty per claim submitted. So once you realize you have a START violation, you have 60 days after receipt of payment to repay. And submission as part of the Self-Referral Disclosure Protocol suspends the 60-day repayment obligation under the Repayment Law. Repayment will be handled through the SRDP settlement process. So again, you don't submit your refund payment like you do with the proposed repayment law. It'll be handled through the settlement process. Given you the web page for CMS, but also the site, since I don't think any human person could possibly read what that website reads. So on the right-hand side, that's the web address. Under the SRDP, the initial disclosure can be made electronically. You can also do it by hard copy, but in any case, the certification, the signature from an authorized person, must be provided in hard copy to CMS. There can be no fax submissions at this point. And you should be aware that there's a significant backlog with these protocols with CMS. CMS may also refer initial disclosure to OIG or the Department of Justice, so disclosure should be carefully drafted. You want to provide all of the information necessary, you want to fully disclose, and at the same time, you want to protect yourself, so how you disclose and how that disclosure is worded can be very important. Required information, again, your typical information, address, NPI, tax ID, organizational chart, while the disclosing party believes a violation occurred, actions taken to address the disclosed matter, whether the disclosing party has a history of similar conduct, that's an important one, and a description of your compliance program, prescription of notices to other government agencies if necessary. And then very important is the financial analysis, total amount by year potentially due based on look-back period. So they want a financial analysis and a methodology, and then finally certification. That all must be included in the START Self-Referral Disclosure Protocol. Repayment is limited to a 4-year look-back period. I've given you a couple of sites there just further describing that issue. You will receive a CMS verification, but part of that is that CMS must be able to access all your financial statements, notes, disclosures, and other supporting documents without assertion of privilege or limitations. So once you step into the world of START Self-Referral Disclosure Protocol, they're going to be able to see everything. CMS may request additional information. Disclosing party will have 30 days to respond. You must cooperate. It's very important. And matters uncovered during the verification process, which are outside the scope of the matter disclosed to CMS, may be treated as new matters outside of the Self-Referral Disclosure Protocol. So just be aware of that. Payments, you do not make payments while the SRDP is pending without CMS approval. But again, encouraged to place money in an interest-bearing escrow account, and you must repay individuals who were improperly billed for services per improper referral. So if a proper referral has occurred, you're going to have to repay the government for the reimbursement on that service, but you're also going to have to repay the patient's copay. And again, this is another statement simply saying that CMS expects that you to work in good faith with them. Lack of cooperation can be considered and may result in additional penalties or fines. Factors considered in reducing amounts owed. So this is the good side of the ledger. The nature and extent of improper or illegal practice. Timeliness of self-disclosure. CMS appreciates timely disclosures. They work with you if you're willing to make a timely disclosure. And then cooperation. That is the big issue. I can't emphasize that enough. The more you cooperate with CMS, the more open with them you are, I think the better off you are. But always with a caveat, while CMS may consider these factors, it's not obligated to reduce any amounts due and owing. But my experience has been that if you are doing your best to report and repay, CMS wants to work with all of us. I think that they know mistakes happen. It's a very difficult regulatory world that we live in, and they understand that. Settlement. After considering the factors, CMS will determine the settle amount. Don't really count on being able to negotiate that. The best time to work out the settlement amount or to improve your standing in the settlement amount is during the investigation process. The cooperation amount or the cooperation provided and the like is the best way to reduce payment. Once they come out with a settlement amount, you're not necessarily going to be able to negotiate that. And the settlement agreement does not relieve the disclosing party of criminal, civil, or other actions except for the Stark issue. There is the opportunity to withdraw. If ultimately the settlement offer is made, you cannot negotiate it, and it is simply unacceptable, you think that it's unfair, you can withdraw from the settlement. But, of course, you also lose the opportunity of settlement. I want to remind you that sanctions for violating Stark are often severe and sometimes lead to disproportionately large damages. But what you will see is that damages under the Self-Referral Disclosure Protocol are not nearly as large or as onerous as they are under the OIG Self-Disclosure Protocol. Here you'll see an exposure of $14 million that was settled for just about $580,000. Here are settlements, recent settlements, and you can see that they run in 6 figures, 5 figures, and 6 figures, but not the 7 figures that we often see with the OIG Self-Disclosure Protocol. Recent settlements, you'll see $231,000, $180,000, $60,000. So they're certainly large amounts, and obviously we want to try to avoid them in any way possible, but they are lower than the OIG Self-Disclosure Protocol amounts. The other opportunity that you have for disclosure and repayment is to simply go to the Department of Justice. So you can go through the OIG, you can go through CMS, you can go through the repayment law, but you can also report to the DOJ. And the benefit is that the DOJ has authority to settle most claims. They can handle False Claims Act violations, they can handle monetary penalty law and criminal statutes. They can also handle common law claims. And depending on your relationship with your local U.S. attorney, they may be more sympathetic. There are risks, however. You have to remember that the Department of Justice is in the business of prosecuting. They are prosecutors by nature. They are not scared of litigation and the like. And they're somewhat of an unknown commodity, and there is no defined process for resolving matters through the DOJ. Also remind you that there are state laws that you must always be aware of. Can't be forgotten. You'll see this, most states have a version of the federal fraud and abuse laws. Many states have their own report and repay requirements. So just be sure that you know what your local state laws involve. So we've gone through sort of the onerous part. Let's talk about the more positive side. What can you do to avoid report and repay or to mitigate the onerous process in the first place? I know everything you've heard so far feels like a ticking time bomb. Here are our best recommendations. It is better to comply. Understand the relevant fraud and abuse statutes. The OIG puts out a work plan, and they have made they have a list of high-risk issues, and amongst those are coding and billing issues, Anti-Kickback Statute, Stark Law, Civil Monetary Penalties Law, and state fraud and abuse claims. They are right at the top. And while the ACA upped the ante on these report and repay laws, they were already going into place. They already existed. They were already getting a lot more playtime, and they are a bipartisan agreement area. This is something that these repayment rules are something that even if the ACA were to be repealed tomorrow, most of us believe these are with us permanently and forever because they return money to the government that people feel have been improperly obtained or retained, even if through no fault of the provider. And so it's important to remember that these rules are probably with us from here on out. There are also good resource materials. The OIG compliance education materials, I've given you a site for that. They're very good. Also, compliance program guidance, you can see there. And as I mentioned, we included the roadmap for new physicians in the written materials today. The most important thing you can do to avoid and be able to survive a compliance issue is to have an effective compliance program. And this means that it's not just something that you want to create and then put on the shelf. It has to be an active part of any practice. You want to have a compliance officer or committee. You want to have compliance policies and procedures. You want to have open lines of communication, regular training and education. I routinely counsel practices to go ahead and make it part of a monthly or bi-monthly, every 2-month meeting. You want to have regular auditing and monitoring. It doesn't have to be extensive or let's make it too extensive, but you want to have some auditing and monitoring practices. And then you want to have a protocol for responding to noncompliance and discipline for noncompliance. It's not that somebody has to be fired for not complying, but you do have to have some sort of disciplinary process for noncompliance, a recognition that a billing practice was not met, and that either retraining or something else along that. This will help ensure compliance. It might mitigate exposure if there's a failure to comply, and we all believe that compliance plans will soon become mandatory for all practices. Check and periodically audit financial relationships with physicians. There you're looking for anti-kickback, civil monetary penalties, and most certainly Stark. You want to consider and document compliance with Stark and anti-kickback exceptions. So if you are doing something that involves referral, but it meets a safe harbor under the Anti-Kickback Statute or an exception under the Stark Law, be sure you consider it and document it. Okay, so if there is a problem, what next? First, suspend all relevant claims until the situation is resolved. Submitting claims with knowledge of a problem could violate the False Claims Act. So not only could you be in violation of Stark or anti-kickback, but now you can be held under the False Claims Act for continuing to submit claims when you know you have a problem. Assess the problem. Is it an isolated event or is it an extensive problem? Is it a computer glitch or was it one human error? Was it knowing misconduct or an innocent error? The amount and type of payments involved. And consider involving a knowledgeable healthcare attorney. Sometimes that can help in evaluating the relevant laws and regulations, whether you really are in violation of the Stark Anti-Referral Law. It might provide some protection if you're acting on the advice of counsel. Some things may then be considered privileged, and it may maximize the attorney-client privilege. Immediately investigate. Remember, the clock is ticking. You have the 60-day deadline. Immediately take steps to preserve documents, including electronic files, gather and review relevant documents, interview relevant persons, and document in your investigation. While that is discoverable by OIG or CMS, it is better to document your investigation to show them that you are on top of it and doing what is required and necessary. Never, ever, no matter how tempting it may be, destroy relevant documents or falsify information. It really does work against you. And then if anything about the Kane case hits home, please remember, never retaliate against whistleblowers. That is a sure way to get into extensive problems. Again, determine whether a violation actually occurred. Consider all relevant regulations and exceptions. Did the transaction involve a federal program? Remember that these violations only go to Medicare, Medicaid, TRICARE, and CHIP. They don't go to private insurers. Were there improper referrals and the like? So you want to evaluate the conduct for violation of a statute. Apply regulations that were relevant at the time. There's lots of different guidances, advisory bulletins and fraud alerts, CMS frequently asked questions. Those are all good sources of information. I won't go through this. There is a potential exception for providers without fault. It's very narrow, but you can read about it. And if a problem exists, fix it. Modify processes, discipline employees, execute, revise, and terminate improper referral arrangements. Remember, fixing the problem prospectively does not resolve past problems or end repayment obligations, but it is a big step with OIG or CMS to show that you are on top of the problem and have got it solved going forward. Implement and document voluntary corrective action plan, always a good idea. Update policies and processes, obtain additional guidance, conduct appropriate training, and the like. And if you confirm a repayment obligation, timely report and repay. Again, I've given you the different laws there: Repayment Law, start violations, intentional or reckless violations of the False Claims Act, Anti-Kickback Statute, where you would use the Self-Disclosure Protocol. And remember, once you take the step to self-report, there really is no turning back. You may withdraw from a settlement, but once you are in the process, you're going to have to go through the investigation. Again, fully cooperate with the investigation. Don't misrepresent. Don't omit material information. Cooperate in every way possible. Don't retaliate. When you're calculating exposure, use a process that you can explain the methodology. CMS and OIG have recommended methodologies for calculating. My next point. That lends credence to what you are telling them the obligation is. Remember to document a settlement in an agreement. The settlement is only between the parties to that agreement. So if you're entering into something with CMS for a start violation, is not a settlement with OIG or DOJ. And remember that this sort of sums it up. It's kind of damned if you do and damned if you don't. But I don't want to leave that on such a negative note. There are ways to deal with misbillings. They do happen. Some of them are completely innocent and can be handled relatively easily with a contractor. Others are more complicated and may result in an action with OIG SDP, Self-Disclosure Protocol, or with the STARK, Self-Referral Disclosure Protocol. It's not the end of the world. The most important thing is to remember to stay on top of any abnormalities, anything that looks like a problem. Be sure to investigate and take a deep breath. Don't panic and work your way through it. We're always here to help. If we can be of any help, we'd be glad to. I've given you a page of additional resources that you may want to take a look at. In addition, we have webinars, typically 2 a month, sometimes 3. I've given you a schedule of the upcoming. We're going to be dealing with HIPAA extensively in February. And I've given you my contact information. We also have publications about most of this information. You have the slides. Most importantly, if you have a question or something I've said is confusing, please don't hesitate to give me a call. I'm more than glad to talk to you anytime. Thank you very much for attending. I'm sorry that I'm 4 minutes over. I hope you guys have a good afternoon, and I hope to talk to you in the future. Thanks. Bye-bye.